Hello, everybody. Olati, are you going to say a few words as well?
I'm just going to introduce them.
Yeah, good. I'm really going to be here for just 1 minute up at the front, and we'll get on with the program shortly. But I just wanted to welcome everybody to the second of the fall's community fora that are under the sort of the heading of community lawyers, community, and impact. It's a wonderful set of conversations we have that some of you have joined us for the first one of the season, which was on policing the police, where we try to put the things that we're learning here in law school into context and see them from the perspective of things that are going on in the world outside. So today's event on voter ID is sure to be a wonderfully stimulating event, and I thank you all for coming, and I will hand the podium over to Olati to introduce our guests.
Great. Thank you, Jillian. So first of all, I just want to be sure that everyone can hear in the back, right? All right, so I'm Olati Johnson. So as Dean Lester said, this is the second event in this series, Lawyers, Community, and Impact. And the idea, really conceived by Dean Lester, was to find a way to connect us all around issues that are deemed important in our community. And the deeming of it as important comes from all of you who have been involved in a range of issues, including policing, police reform, and also issues around election and election reform. And of course, these issues are particularly salient this year. So my job, since we only have a limited amount of time here, is just to introduce the speakers today. And first, we're going to start with Richard Briffault, who is going to tell us everything we wanted to know about voting rights around the theme of this question of voter ID and voter access. All of you know this past summer has been one in which there's been a lot of litigation around this question of accessing the ballot. For the past several years, we've seen restrictions on the right to vote. So Richard Briffault, who teaches here, he teaches legislation and property, state and local government law, a law of the political process, and is really expert on election law, is going to really set it up for us and tell us how we got to where we are, what's the doctrinal landscape, and the history in this area. And then next we have Julie Ebenstein, who is a staff attorney at the ACLU Voting Rights Project. She also has a wonderfully interesting background that I hope the students get to engage you with in doing lots of different areas of law, not just election law, but also has done immigration and refugee law in the past before voting rights. I can say that Julie's also our own, even though she graduated from Fordham Law School, is a Columbia undergrad, a graduate of Columbia College. So first we're going to start with Richard, and then we'll turn it over to Julie. And let me just say one last thing as you're getting up, actually, is that we're trying to find a way to make some of the documents that we produce here enduring for people. Folks have asked, can we have the slides? Can we have some of the articles you reference? So we do want to create a website that allows people to have access to things when it's appropriate. Okay, so thank you, Richard.
Thank you. Thank you, Olati, and thank you, everyone, for coming. I see at least a couple of people from my law political process class. There will be a pop quiz for you at the end, since you have all gotten this material twice, including some of it yesterday. So hopefully you are permitted to close your eyes and just eat your lunch, but you're also entitled to the lunch. As Olati said, I think we sort of view this as a two-part story. I'm going to do sort of the setup, a little bit about the background on the right to vote, and the emergence of administrative issues in voting, voter ID, and other things, and give a sense, a little bit of the doctrinal framework and of the scope of the litigation problem. That we really do have reached the stage of the intense politicization of voting. Now, in some ways, it's always been political, but I think you have a sense that there's been a crescendo of the politicization of voting in recent years, and I think I'm trying to set that up, and I think Julie will then walk you through the minefield, the front lines of actually two of the most important areas in which litigation, two of the most important states in which litigation has been occurring and which in fact top on almost all the issues. So I want to begin with the right to vote. The Supreme Court long ago observed that the political franchise of voting is regarded as a fundamental political right because it is preservative of all rights. It's a funny thing, the Constitution itself doesn't literally confer the right to vote, although many state constitutions do. What the Constitution does is, in place after place, eliminate certain grounds for denying the vote, such as the 15th Amendment on grounds of race, the 19th Amendment on grounds of gender, the 24th Amendment poll tax, 26th Amendment age, if extending the 18-year-old vote. 17th Amendment is also relevant. 17th Amendment is what made the Senate elective. Originally, the Senate was chosen by state legislatures. And the 23rd extended the right to vote in presidential elections of the District of Columbia. Many people have observed that although the right to vote per se is not in the Constitution probably gives, the amendments of the Constitution probably give more attention to voting than to any other subject. Doctrinally, drawing out of these provisions and the court's sense of the importance of the right to vote, the court has determined that voting is a fundamental right, particularly for purposes of equal protection analysis. For those of you who've gotten that far, so when the court reviews, here's equality challenges to government laws, to restrictions, it has this two-tier analysis, and the strictest review is reserved for laws that impinge on a fundamental right. Voting is one of those rights. In some ways, it is the poster child of fundamental rights, and restrictions on the right to vote are subject to strict judicial scrutiny. As a result, when I realized I typed in the word all, and as a professor, I should almost never use the word all. I'm having seen this, oh my God, what did I do? All is dangerous. Let me say presumptively, growing out of the combination of constitutional provisions and doctrine, presumptively all adult resident citizens, resident in terms of you get to vote where you live, are entitled to vote. With the one big exception, and it's probably worth a program in its own right, is the treatment of people convicted of a felony. There's a variety of constitutional reasons for that, and an extensive amount of both legislation and litigation and recent actions by the governor of Virginia on it. That one will get its own program. But putting the persons convicted of a felony to one side, the idea of being entitled to vote presumptively applies to all adult resident citizens. Where the action has been in this aspect of voting rights in the last, I'd say, decade and a half, and in some ways it was really got the most prominence from Bush versus Gore, the 2000 decision, but in some ways it goes back maybe 2 decades or more, is the emergence of what I'm calling administrative issues in voting. Not what kind of person is entitled to a vote. Do you have to be a taxpayer or not? Do you have to be literate or not? Those have been put to one side. But these other things, registration requirements. Most states require that before you vote, you actually have previously registered to vote, that you've proven that you've satisfied the requirements. And there have been issues about the timing of registration. How far before election day does it have to occur? Where does it go? Where does it occur? What do you have to show to show that you meet the requirements, which by age, residency, and especially citizenship, where there's been a new focus on that. Big issues about election machinery and election day issues. You may not, I still remember the hanging chads. But all sorts of questions about what is a legitimate voting machinery and what happens when there's different quality machines in different parts of the state. Issues involving so-called provisional ballots. When people show up to vote, they are registered, but their name doesn't appear in the roll where they vote. We now require that they be given provisional ballots, but that in turn has generated legal issues. Other issues, the numbers of polling places. The recent Arizona primary was a disaster because the state had reduced the number of polling places and their locations. And that connects directly to waiting times. These have all emerged as mixed litigation, legislative, and policy issues. And some things have involved expansion of voting. There is a sense that this is all about reaction over a lot of expansions. Some of the rules have actually made registration easier through online registration, same-day registration in some states, automatic voting registration in some states. There's been an expansion of absentee voting, mail-in voting, and early in-person voting, although some of the current litigations involve efforts to cut that back. The so-called souls to polls idea of people basically going to church on Sunday and then going together to vote. And there have been issues involving the fact that so many of our election administrative bodies and decision makers are partisans, elected on party lines, and often seeming to take party into account in some of their actions. This again was very dramatic in the 2000 election. Voter ID, turning to sort of the subject of the day, there were no voter ID requirements before about 1950. Voter ID is a relatively modern phenomenon, and even as late as 1980, only 5 states required some form of ID, and none of them required a photo. And indeed, having talked about voter ID, what we're generally talking about is government-issued photo ID. That is really where the fighting has been. Indeed, up until the year 2000, no state required government-issued photo ID. You might have to provide something, such as a rent bill or utility bill to show that you lived where you said you lived, which meant you could qualify to vote where you were voting. But this was the issue. The requirement of government-issued photo ID is a relatively recent one. Georgia and Indiana in 2005 became the first states to do that, and to require a relatively strict definition. Driver's license, passport, or some other government-issued ID, and indeed we'll talk about it in a minute. Not all government-issued ID counts in all states. In some states, for example, public assistance ID might not be counted, although a hunting license might be. And then the big marker in this, in the evolution of voter ID, is in 2008 when the Supreme Court, in the Crawford versus Marion County case, upholds Indiana's law, and we'll talk more about that in a minute. So voter ID today, the numbers are a little bit in flux. These numbers are pulled from a website maintained by the National Conference of State Legislatures, that's the NCSL up there, that 34 states now have laws requiring or requesting voters to show ID in order to vote, with 32 of those currently in force. So I think one of the two missing ones is suspended, and the other one is to take effect in the future. The NCSL considers 10 of these to be strict, which is to say a narrow definition of the photo IDs required and minimal alternatives, including Ohio and Wisconsin. Another 10 are deemed non-strict, but to require a photo, but provide for some alternatives. As I said a second ago, the states do vary in terms of what counts as a photo ID. Some of them are more expansive, some are not. One of the big issues is state university ID. Obviously, you can tell that that's quite significant if the IDs issued by the University of Wisconsin or the University of North Carolina count or not count. Those are state institutions, but some places do not count state-issued IDs, state university-issued IDs. Other states continue to follow the old form of having something less restrictive, and many states, including our own, benighted in many other election voting respects, New York, just requires signature matching. When I go to vote, they have my signature on file. It's arguably still the same, although I first signed it a long time ago. I just sign again, they match it up, and in theory, it should show that I'm the same person. Turning back to the law in this area, the big case, the only Supreme Court case, is a case called Crawford versus Marion County Board of Elections. It was decided in 2008, and it was involved this challenge to Indiana's strict law, Indiana being one of the first states to adopt a strict law. There's a three-way divide in the court. The lead opinion, the middle, is written by Justice Stevens, joined by Chief Justice Roberts and Justice Kennedy, applies the so-called Anderson-Burdick sliding scale, which I'll talk about more on the next slide. They treat this as a facial challenge to the Indiana law. Is government-issued photo ID permissible in principle? The court, this group, the plurality, says yes, but then leaves open the possibility of as-applied future challenges. They basically said the argument that this is really burdensome, haven't given us any evidence, and we don't think it's all that burdensome, we'll let it go forward. The Scalia concurrence agrees on the point that photo ID is permissible and says it's permissible in all cases, and that therefore we're going to reject as-applied challenges. The two dissents, Souter joined by Ginsburg and Breyer dissent, basically say the case isn't made. Turning to a little bit more on the Stevens opinion, the Anderson-Burdick test is kind of a sliding scale. The idea is, although the right to vote restrictions on the right to vote are subject to strict scrutiny, in some sense, all rules dealing with voting could be treated as a restriction. The fact that voting hours are from 6 a.m. to 9 p.m. denies the vote to people who want to vote at 10 p.m. The fact that we vote on Tuesday is inconvenient to people who'd rather vote on Monday. So the court has said we can't look at every single provision dealing with voting and subject to strict scrutiny. We're going to look at the magnitude of the burden on the right to vote. If the magnitude is great, the justification has to be strong. If the magnitude is not so great, the justification can be weaker. And the Stevens opinion basically says the magnitude of the burden on the right to vote from requiring ID is not great. Of course, Stevens says most people have ID. In addition, Indiana and most states that have adopted this requirement offer the option of issuing you a free ID. Typically, it's done by the DMV, Department of Motor Vehicles, because for most people, the ID is a driver's license. And Indiana also offered the option of casting a provisional ballot and then coming back 10 days later with some proof within the next 10 days of proving your ID. As I said, though, he did leave open the possibility of an as-applied challenge by those for whom the burden is particularly severe. People can show that it's really hard to get that free ID, the one that the DMV will offer to non-drivers on proof that they satisfy the requirements. That might be a possibility. He just leaves it open. Why is it, given that the burden is not great, it still needs some justifications? What are the justifications? The two big ones are the possibility of in-person voter fraud. That is, people talk about voter fraud, but the only kind of voter fraud that ID would require is somebody showing up at the polls and saying that they are a person who's registered there, but not actually being that person. That's what's known as in-person voter fraud. Finding out that there's somebody on the polls, say, who is dead, and saying, I am that dead person. I'm not dead, of course, but I am that person. Or in some other, say, finding out that there's somebody who's registered and who's not going to vote that day and showing up and pretending you're there. As Stevens acknowledges, there's no evidence of any such fraud actually occurring in Indiana at any time in its history, but it could happen. And so the state has a legitimate interest there. And just as important, it's important to safeguard voter confidence that fraud isn't happening. There's been a lot written about voter fraud before and after that decision. There are books and many articles. This is an extremely small print selection of the many studies on voter fraud. The one I like the most is the Washington Post study, which says it found 31 credible instances, not proven voter fraud, but 31 credible instances out of about 1 billion ballots that were counted, that were cast over a 14-year period. There was a special Department of Justice unit created during the Bush administration, which was interested in finding federal election fraud. They examined all the federal ballots between 2002 and 2004, and I can't even figure out what that number is. That 0.0000013% were fraudulent, none of which involved in-person fraud, but might have involved manipulations by administrators. Two of the big recent cases, the Fifth Circuit decision involving Texas and the Fourth Circuit decision involving North Carolina, give the judges there comment on what was presented in their cases. The Kansas Secretary of State is interesting. That's Chris Kobach, who's one of the leaders in pushing for tighter restrictions on voting. He did a study in reviewing 84 million votes cast in 22 states and found 14 instances of voter fraud prosecutions. Again, it's a really small fraction. And then Judge Posner, who I'll be quoting several times for a couple of reasons, has, in a recent decision of the Seventh Circuit, says that some of the evidence of voter impersonation fraud is downright goofy, if not paranoid. Posner is relevant here for two reasons. One is beyond the fact that he is a longstanding and brilliant judge, he is considered to be a conservative judge, and also when the Crawford case was coming through the pipeline back in around 2006, 7, 8, he was on the Seventh Circuit panel that upheld it, that upheld the voter ID the first time up. He has since, as this comment and a couple of others indicate, changed his mind. And in this case, Frank versus Walker. Walker is the governor of Wisconsin. This involves the Wisconsin voter ID law, and I know this violates all the rules of PowerPoint to have a big block quote up there, but I love this one. As Judge Posner observes in 2014, voter impersonation fraud is, by all accounts, a tiny problem, and a mere fig leaf for efforts to disenfranchise voters likely to vote for the political party that does not control the state government. Those of us who live in Illinois are familiar with a variety of voting frauds, and no one would, some of you are familiar with Illinois, and no one would deny the propriety of the laws trying to stamp out such frauds. But one form of voter fraud known to be too rare to justify limiting voters' ability to vote by requiring them to present a photo ID at the polling place is in-person voter impersonation. The other issue is voter confidence. The major study on this is by Stephen Ansolba here and Nate Prisley, who is formerly of this law school and is regrettably no longer here, has gone to Stanford. They did an excellent study that says that perceptions of voter fraud are unrelated to the strictness of the state's voter ID law. I recently also came across an interesting piece in a journal called Political Psychology, which suggests that sometimes these voter ID laws may, if not backfire exactly, have the effect of undermining confidence in voter laws on the people who feel that they're being targeted by voter ID laws. So it's not at all clear what extent, if at all, voter ID laws promote confidence. Indeed, all the talk about fraud may very well undermine confidence. There's also the theme that emerges as early as the Crawford case and is very strong now, that voter ID law, and you already saw it in the Posner quote, that voter ID laws are connected to partisanship. This was argued in the Crawford case, and Justice Stevens dismissed its significance. If a non-discriminatory law is supported by neutral justifications, he says, those justifications should not be disregarded simply because partisan interest may provide one motive. If there's a good law, the fact that the people supporting it were all on one side should not be a basis for disregarding it. And indeed, the data indicates that virtually all, not all, but this is one where it is truly not all, but nearly all strict laws were adopted in states with both a Republican governor and Republican state legislature. And again, one more big quote from my friend Judge Posner. I'm becoming his biggest fan. The data imply that a number of conservative states try to make it difficult for people who are outside the mainstream, whether because of poverty or race or problems with the English language, or who are unlikely to have a driver's license, to feel comfortable dealing with officialdom, to vote because if they do vote, they are likely to vote for Democratic candidates. it is pretty much a given now that this has become, this and other changes in voting law have become, are being seen as partisan tools. They're being pushed or resisted because of the belief in terms of which people they're likely to be affected in terms of how they're going to vote. Voter ID and other election administration issues. Voter ID is not the only one, although it's gotten the banner, are now being intensely litigated and have been really since a couple of years ago. 15 states, according to the Brennan Center, 15 states have new voting laws that have never been used during a presidential election. Either they were adopted before 2012 but suspended due to litigation, or they were adopted since 2012. Many were adopted post-2014 when there was a major shift towards Republican control of state legislatures. There are litigations either ongoing or ongoing but temporarily on pause in Alabama, Arizona, Georgia, Kansas, Michigan, North Carolina, North Dakota, Ohio, Texas, Virginia, Wisconsin. That is an incomplete list. I'm not sure I could develop a complete list. With major decisions recently, and by recently since July, really most of these decisions are within the last 2 months, because a lot of them were some in late July, from some of the major courts of appeals, including the 4th, the 5th, the 6th, and the 7th, and of this, dealing with North Carolina, Texas, Ohio, and Wisconsin. And it is probably no coincidence that at least 3 of those fall within the fabled category of swing states. My last slide, because this really is the setup for Julie to take over, is for voter ID. As I see it, there have been the following 4 major issues. Crawford governs the field. So per Crawford, and what governs the field is the Stevens opinion. Voter ID is constitutional on its face, but it can be challenged if you can make the case that that a lot of voters are burdened, and they're burdened in a pretty severe way. And especially that it is difficult for them to get the free state voter ID that the states offer, because typically in order to get that ID, you have to have some other ID. And people may not have that ID and may have to spend some time and money to get the ID you need to get the free ID. Related to that is whether most states, in response to litigation, have added provisions that are designed to provide an alternative to voter ID for people for whom there is a reasonable impediment to getting voter ID. Much of the litigation is focused on, is this reasonable impediment exception? What is it? What does it have to provide? And it is an inadequate remedy. A second set of cases, and they're all the same, and some of these issues come in all the cases, so it's not like they're necessarily sectioned off, has focused on the evidence of disparate racial impact of voter ID, as well as other election law changes, particularly the changes to early voting. And most dramatically, as those of you in my class who were paying attention, I hope, yesterday know, that in at least one major decision, actually there were 2, but a district court decision, a court found that the motivation behind passing voter ID and other election law changes was sufficiently racially intended as to violate the 14th Amendment. And with that, I'm going to turn it over to actually find out how this actually works in the field.
Thank you.
Okay. Did I walk off with something?
No, I just.
You want to get rid of that? Okay.
Yep, just this one.
Thank you. Hi, good afternoon, everybody. I'm Julie Ebenstein. I'm with the ACLU Voting Rights Project. We litigate across the country only voting rights and voter suppression challenges, usually having to do with either racial discrimination or barriers to people registering voting and having their vote counted. So I'm going to pick up the story around 2008, which had 2 significant components. Not only did it include the Crawford decision, but on top of that, as we all know, the election of Barack Obama. 2008 saw the youngest, most diverse electorate that this country has ever seen. The differences in turnout based on race were pretty much eliminated, so that white turnout was around 66%, turnout for African Americans was around 64%. And I think this new and changed electorate really influenced how state legislators, I'm going to leave the PowerPoint alone, how state legislators saw their job when it came to voting. Instead of being broader and more inclusive, and trying to bring in this new electorate and appeal to them in the policies that legislators wanted to pass, what legislators did was really pass suppressive laws so that they could narrow back the electorate into the known group that had always turned up in the past. You can break down the last 8 years into maybe 3 different buckets, so to speak. 2008 and what I just described until 2013. 2013 when we had the Shelby County decision, and from 2013 until present. We've intensely litigated all of the issues that were just mentioned throughout that time period, and particularly in the last 3 years since we lost preclearance under the Voting Rights Act, which I'll describe in a moment. So what did the backlash look like? State legislators responding to the 2008, both the election and the Crawford decision allowing voter ID and other suppressive voting laws to go forward. We saw suppressive laws all over the country, and they aren't just with regard to voter ID. I think people use voter ID as a shorthand to talk about a number of different suppressive efforts on the part of state legislators to prevent certain people from voting. Voter ID prevents anyone without an ID from voting, obviously, but there's very targeted cuts to different kinds of voter access provisions. There is diminishing access to early voting, and it's not, we don't have early voting in New York. We find it's usually less common in the Northeast, but in places like North Carolina, where we're litigating, over 50% of people who cast a ballot cast it during early voting. The North Carolina legislator, as I'll explain in a moment, took away 1 of the 2 weeks of early voting, which really compromised people's access. Another way to diminish access is to get rid of out-of-precinct voting. So in New York, you have to vote at your assigned polling place. In some places, again, like North Carolina, you on election day, you can go to any number of polling places, one near your office, one near your home, and cast your ballot there. That provides a level of convenience, in particular to folks with less access to transportation, less time if they have childcare or work issues that they can't move around, and a number of other barriers that we find, and we've proven in North Carolina, are more prevalent for lower socioeconomic groups and more often for African Americans than for whites. We've also seen these documentary proof of citizenship requirements, specifically in Kansas, where we are involved in not 1, not 2, not 3, but 4 separate lawsuits against the Secretary of State, Chris Kobach. This is a requirement that not only do people have to sign under penalty of perjury a federal form to register for elections, but they have to provide some sort of documentation of their citizenship. Now, we all know that in the calculus of voting, one of the reasons people don't turn out is if there's any barrier in their way. A lot of people will just say, oh, forget it, right? So if you try to register, if you ask to register, if you request to register, you think you're registered, and you show up on election day, and you're told, sorry, you didn't provide a photocopy of your birth certificate or your passport, then you may not make that trip again to try to correct the error. These small deviations, these small changes, whether it's early voting, out of precinct, documentary proof of citizenship, or photo ID, really remove a segment of the population from the electorate. And in many instances, we believe, and many courts have agreed with us, that they're targeted to do just that. They've actually been, in some instances, quite effective. From 2008 until 2013, we had this wonderful thing called Section 5 of the Voting Rights Act. Are folks familiar with Shelby County, the decision in 2013? Okay, heads are nodding. So here's what Shelby County did. Back when Section 5 was operative, in covered counties, the state would have to go to the Department of Justice or a 3-judge panel in the DC court and seek permission, basically, whenever they were going to change a law or policy that affected voting. They would have to get the federal government to approve it on a finding that it was not retrogressive to language or racial minorities. Now, what did this mean in practice? This meant that not only were litigation groups and interested parties and voters informed when a policy was changing or when a voting rule was changing, but the timing was different. So before it could be implemented, litigation was worked out before this potentially discriminatory law went into effect. A good example is Florida. where I lived up until for a few years until the 2012 election, and pretty much every type of voter suppression that we've seen in Florida. When preclearance was operative, Florida had to pass cuts to early voting, had to pass additional signature requirements, had to pass all these provisions through the Department of Justice before it could be implemented. Another piece that made Section 5 so strong was that the burden was on the state to prove that it was not retrogressive. Who carries the burden in court is hugely influential. So we're in a very different position now when we need to prove that a law is discriminatory under a slightly different standard than we were pre-2013 when the state had to prove that a law was not retrogressive. On top of that, well, I'll leave it at that as far as Shelby County goes. What happened during the Shelby County decision? The court decided that this formula was outdated, despite the fact that it had been reauthorized 5 times since it was passed in 1965 and as recently as 2006. This formula, which created some covered jurisdictions and some uncovered jurisdictions, and only required the covered jurisdictions to seek preclearance, was struck down as unconstitutional. Again, this statute was reauthorized, so this is really the height of congressional power to pass a law like this. And it had been implemented since 1965 until 2013. Now that we lose, there was, I think, 2 wonderful quotes in the Shelby County decision. One was from Roberts, who wrote the decision, who said, "Voting discrimination still exists. Nobody doubts that." And if anyone did doubt that in 2013, when that decision came down, they certainly don't doubt that now. In addition, people are familiar with Justice Ginsburg's quote, "Throwing out preclearance when it has worked and is continuing to work to stop discrimination changes is like throwing away your umbrella in a rainstorm because you're not getting wet." And that's certainly how a lot of people felt about it. Let me see if I can, well, sorry, all PowerPoints are not my forte. What have we seen since Shelby County? Well, what we saw immediately. North Carolina, for instance, passed an omnibus election bill immediately after the Shelby County decision. Texas passed an omnibus election bill that had been struck down under preclearance. Once preclearance was gone, they immediately passed the exact same legislation and the exact same restrictions. Now you have to ask, and I'll get to this in a moment as far as the state interest, why? When you know that there's going to be expensive litigation, when you know that this law is going to have at least a retrogressive effect, and in many instances a discriminatory effect, what is the purpose of passing these laws and setting off this back and forth, which has the potential to cause voter confusion and really doesn't benefit the voters that you're supposed to be working for? North Carolina, I want to speak to the litigation there. We filed a lawsuit the day that law went into effect in August of 2013. And we challenged 4 of the provisions that I just described. We challenged a photo ID requirement. We challenged a cut of 1 week of early voting from 17 days to 10 days. We challenged a same-day registration, elimination of the same-day registration provision, which allowed people to register and vote on the same day during early voting. We challenged the elimination of out-of-precinct voting, which people could undertake on Election Day itself. And there was an additional 26th Amendment challenge to discrimination against young voters. Well, here are those 4. The litigation took place over the last now more than 2 years. There we go. Like I said, we filed in August of 2013. We sought a preliminary injunction and had a full hearing in the summer of 2014. The district court denied our preliminary injunction, and the Fourth Circuit reversed 2 parts of it, the same-day registration part and the out-of-precinct voting part. At that point, we were already up to, I believe it was October of 2014, when we got that decision from the Fourth Circuit. And that was immediately brought up to the Supreme Court, by the defendants who sought a stay of that decision. Now, you'll see this, hopefully not so much this year, but in 2014, you saw a lot of cases bounce up to the Supreme Court on a stay request. It was really a 3-week period before the election. We saw Texas, Ohio, Wisconsin, North Carolina, all ACLU cases that we're involved with, and whoever lost the case going to the Supreme Court to say, no, stay this decision, it's going to cause confusion too close to the election, we can't change the rules of the game at the last minute. So the Supreme Court stayed this beneficial to voters Fourth Circuit decision, and the election went forward without same-day registration or out-of-precinct voting. That's 2014. That's how we wrapped up 2014. In 2015, this case went to a full trial. We spent 3 weeks in Winston-Salem, North Carolina. It was fully litigated, with the ID component going to trial in January of 2016. And later in 2016, we got a 485-page decision from the district court. So books on the Civil War have been written in less pages than this court decision, denying every single one of our claims. We immediately appealed to the Fourth Circuit, and that's the decision that is standing now, which determined that this was discriminatory, not on Section 2 of the Voting Rights Act, which speaks to discriminatory effect, but that the law was intentionally discriminatory. And speaking of quotes, here we go. Here are some of the things that the Fourth Circuit said regarding this law. First, with surgical precision, North Carolina tried to eliminate voting practices disproportionately used by African Americans. Back to this point about party and race, the North Carolina legislature targeted voters based on race because they believed that African Americans in particular were more likely to vote Democrat. And in many ways, and this speaks to both the state interest and the burden, the balance of those two in Anderson verdict claims, in many ways the challenge provisions constitute solutions in search of a problem. So I think there's really, after that the jurisdiction applied for a stay to the Supreme Court, which recently denied that stay. We assume that the jurisdiction is going to seek cert October 27th, and we'll respond to that. So this is a case that's still ongoing. But all of these provisions that North Carolina tried to eliminate are still operative for the upcoming election. I think there's 2 points about the North Carolina decision. One is that it's unlawful to use race as a proxy for party. In some states, and North Carolina is one of them, voters' race correlates very strongly with who they end up voting for. I've read before that race, in fact, even as much if not more than party registration, determines the predictability of a voter's vote. This is not a justification for targeting certain voters. This doesn't get, as a state legislator, this doesn't get you out of either an intentional discrimination claim or a Section 2 claim. The next point is that courts were really willing to scrutinize, were really willing to consider both the burden that these laws have on voters and to scrutinize the state's justification for restrictions. Like I said, they found zero instance of in-person voter impersonation fraud in North Carolina, and it wasn't enough anymore after Crawford for the North Carolina legislator to say, well, we want voters to have confidence in the system and we're preventing the potential for future fraud. Based on our evidentiary record, the court really recognized that there was no justification at the time this was passed, and there must be another explanation for why the law was passed. As far as folks who plan to undertake litigation after they finish law school, I think this is really key to how voting rights cases work. They're very, very fact intensive. You have expert witnesses, you have lay witnesses, you produce tens of thousands of documents, and you really have to show a federal judge who may be very far removed from the burdens that these voters face, how that burden impacts an individual voter's ability. So what we saw in Wisconsin, which I'll describe briefly in a moment, was that the Seventh Circuit said how could somebody live in this world without ID? They couldn't get on a plane, they couldn't go into the courthouse, they couldn't get a prescription, and not only were they incorrect on the fact, you actually can do those things without an ID, but there was really a failure to consider the day-to-day lives of many of our clients in these cases and residents of the states where these laws are passed. Moving to Wisconsin, and I'll be a bit brief talking through this. Wisconsin passed a pure photo ID law in that time period between the 2008 election and the Shelby County decision. And I want to describe the challenges that two of our individual plaintiffs faced to give you a sense of how this plays out in practice. One of our clients was Ruthelle Frank. She was born in 1927 at home, and she had voted in every single election since 1948. There was a record of her birth, so the state had her birth certificate, but she could not get that birth certificate unless she paid, I can't remember the precise number, but a very costly amount for her to get an extra copy of this birth certificate because her maiden name was spelled incorrectly. So to get a correction through the state of her name on the birth certificate so that it matched her current name as she's registered would have cost her upwards of $100. There's another client, Eddie Lee Holloway is his name, Eddie Lee Holloway Jr. His birth certificate says Eddie Jr. Holloway. And while he could have accessed one type of ID, he didn't have the money excuse me, to change his name on the ID. He had some very powerful testimony during the trial where we established that the cost of him changing his name officially would be $200 to $300. And my colleague asked him, do you have $200 to $300? And he said, sir, I don't have 2 to 300 cents. Now I think that he's presently homeless, or he was at the time of the litigation. He had fallen on some tough times, and he really faced barriers, any number of barriers, financial or just access to transportation, in order to get an appropriate ID. So these are the stories that we really need to tell in the context of litigation. Like North Carolina, the Wisconsin case, and I will put these up. It is meant to look confusing because the decision is quite confusing. Here's the yo-yo of back and forth that we've seen in Wisconsin. The district court says that voter ID is unconstitutional. The 3-judge panel of the 7th Circuit says no, it's not. The en banc panel says 5-5, we don't know, so the 7th Circuit panel stands. There's no stay granted, so photo ID is not in effect there. It gets complicated, but there's a question of whether you can bring an exception to this case that only applies for those who face a reasonable impediment to obtaining an ID. The district court says no, then the 7th Circuit says yes, so the district court rules on this reasonable impediment. The 7th Circuit then disagrees with the ruling, and they seek a stay. What does this back and forth add up to? I think really it's two things. First, it creates a lot of difficulty when it comes to voter education, and that in itself can decrease turnout. So getting out accurate, consistent information on what one must do to cast their ballot is hugely important. Two, I think it highlights some of what I said earlier as far as the challenges to litigation. So again, because now we have to litigate after a law is passed, instead of looking towards preclearance before a law is passed, there's this back and forth, particularly intensely leading up to an election, on what law is going to be in effect for what election. It's changed back and forth in these two states and in others immediately prior to elections, and it becomes very confusing for voters and very exhausting for litigators. So I think there's two significant things to consider. One, and I haven't spoken about this specifically, but how Section 2, the remaining section of the Voting Rights Act, will develop. This thing that protects against the disparate effects of voter laws. How will this develop? What will the standard be going forward? And will it get up to the Supreme Court in North Carolina or otherwise? The other is how this balance will be struck. Will the Supreme Court, if they take this up again, treat it like the women's health decision and really scrutinize closely whether there is a state interest at all that justifies creating burdens for voters? Or will the states be given a free pass, so to speak, where public confidence is simply enough to disenfranchise hundreds of thousands of people. I think that remains to be seen, not before the 2016 election, but perhaps soon after. And thank you all for coming today and for your interest in the voting rights work we do.
Thank you, Julie and Richard. I think we do have time for questions. So, questions?
Could I just say one little thing?
Yeah, sure,
This is an relatively down presentation, I think, by both of us. I just want to say sort of one somewhat positive thing, which is that not all voting law changes have been in the retrogressive direction, and a number of states have also, and so a positive legislative change is possible. A number of states have actually tried to liberalize voter registration. A number of states have now, and the trend is increasing, have adopted something called automatic voter registration, which makes it easier for people to be re-registered when they moved. It puts the burden on the state to find them. A number of states have added early voting. A number of states have liberalized absentee voting. So, not to take away from any of the bad stuff that's happening, but it's not all one-sided. It's a lively, contested area in legislation, and as well as the actions of many states there are efforts in many states to change some of the laws involving felon disenfranchisement, including the rather dramatic effort of Governor McAuliffe in Virginia this summer. So it's important that you can be mobilized both on the litigation front, but there's also legislative action that happens.
Right. Well, I mean, you're saying that also reminds me that that's one of the issues that really confounds people, especially who have been or familiar with other legal contexts, is the idea that when you're creating a system for regulating federal elections, that you could have such disparity between states in how that's regulated. But I want to throw it out to you for questions. Things you want to know more about. All right, in the back.
I wonder if the Voting Rights Project does work on felon disenfranchisement. It's difficult to litigate that because
Very difficult.
And what type of work are you doing on that? How you're trying to
So like you said, those are the, and we are often the bearers of bad news because we're not brought in unless something goes wrong. But there are certainly improvements being made to some aspects of voting. On the felon disenfranchisement front, it's very, very difficult to litigate in federal court. So because a lot of rights restoration after somebody loses their right to vote based on a felony conviction takes place within the clemency process, that's basically a bit of a black box that you cannot, or people have not been successful thus far, challenging under protection against racial discrimination. The Farrakhan case is out of the Ninth Circuit. That wasn't successful. There have been a number of other ones. I was just involved in one litigation, one where we filed an amicus brief on felon disenfranchisement. We thought it would be helpful to go through state courts. So in Iowa, we challenged their felony disenfranchisement provision based on the state constitutional definition and what we thought infamous crimes could include. Our plaintiff, I'll be quick, but our plaintiff had a drug possession charge from years earlier. The rules on restoration had changed so that she thought when she finished her probation sentence, she would automatically get her rights back. Instead, that didn't happen. When she went to register and vote, she was charged with fraud, acquitted of fraud, but she still didn't have her rights back because of this drug possession conviction. We said that drug possession, especially in the way that it's been applied in modern times, is not an infamous crime requiring that somebody lose their voting rights for life, but we were not successful at the state Supreme Court. The Virginia decision, the governor there tried to restore rights to hundreds of thousands of people, and a few individual state legislators, along with individual voters, challenged his authority to do that. We filed an amicus brief on the side of the governor, but unfortunately, that state court also said that, ruled against voters and determined that the governor could not do this blanket restoration. So we're certainly working on felon disenfranchisement as an issue, but it has been very, very difficult to address through the courts.
When courts have struck down in the rare occasions kind of race-based voter restrictions, have the legislators in those states gotten creative and opted
So have they gotten creative going forward or in their arguments in court?
Both.
Both. North Carolina is a good example. I'm just going to. North Carolina is a good example of that. Our challenge there was both on constitutional grounds for intentional discrimination and Section 2 of the Voting Rights Act, which relates to disparate impact and a link to historic discrimination. And there it was interesting because the defendants, the state and others, brought up this argument, hey, we weren't discriminating on the basis of race, we were just discriminating on the basis of party. Now, what the Fourth Circuit found there, and I think I had one of the quotes up before, is that you can't target black voters because of their the way that the partisan inclinations in the state of North Carolina. So it was not sufficient for the state to basically admit, yes, we targeted black voters, but because they're Democrats. That was not a sufficient justification for disenfranchising this group. And they actually ruled on intentional discrimination, which oftentimes is much more difficult to prove than disparate impact. So it's certainly, there have been a lot of creative arguments brought up. I think preventing fraud is a bit of a creative argument, since the two cases I just discussed, there were exactly 0 instances in-person voter fraud. But every time there is a success, there's more creativity on the part of legislators.
The North Carolina, you should take a lot of credit. North Carolina case really is a landmark, I think, on this intertwining of race and party. We talked about this in class the other day. Believe it or not, in other cases involving voting booths, but mostly in the gerrymandering context, the Supreme Court has taken a sharp distinction between racial discrimination and partisan discrimination. And in the gerrymandering context, the court has said that partisan gerrymandering is not great, but it's not unconstitutional, whereas racial gerrymandering is, which has led the court on a number of occasions to figure out, is this race or is this party? And you can see the argument that the state was trying, racial discrimination means discriminate. What the court was basically saying is that racial discrimination doesn't just mean based on hatred or animus. I mean, there's some language like that. People in class yesterday were like, what are they talking about? That you can see that the reason could be because of political affiliation that correlates. And whereas in other settings, the Supreme Court had actually said to try to take two things which are very intertwined in many places and put them in separate buckets. I think this may be one of the first cases that very clearly says they're not when they're not different in fact, they can't be given as different arguments.
Yeah. It was really, and I actually have the citation here. If any of you have a chance to if any of you have a chance to read the decision, this is not the 485-page decision. This is the Fourth Circuit. Oh, I don't even have it. Anyway, I can give it to you all afterward if you're interested. But it really was. It was a wonderful decision, looking at how race and party overlap, and the limits on the power of the legislator in that regard.
I think one of the things just to think about, sort of stepping back from the doctrine and the doctrinal advancements that you made in that case, is just the idea that a state got up and said that they might have legitimate aims in partisan, even targeted. I mean, that may seem normal to you in the voting area, but I mean, think about that, right? As a way of thinking about election and election access, and for me at least, it raises a question about just sort of the politics of this more generally. If there, you have this kind of data on its effect on voter confidence and maybe a kind of backlash, but I'm wondering that there isn't more democratic accountability, and that courts are the main way to fight this, that people aren't sort of saying on both sides of the aisle, so to speak, that maybe we've gone a little too far here if we're trying to disenfranchise voters for any reason or make it more difficult for any reason. So I don't know if there's a last question.
Can I just follow up on that?
Yeah.
Just one thing to add to that.
I want to give you guys both a chance to say a last word.
North Carolina is a great example of that too. One of the questions that came up is when you have more expansive access provisions, when you have early voting, when you have out of precinct, when you have same-day registration, things that states like New York don't have, is it a one-way ratchet? So once a state passes those provisions, can they not take it back? And so what the defendants argued in that case was, well, the Democrats passed particular provisions that worked in their favor, and for partisan reasons, we got rid of those provisions because that worked in our favor as Republicans.
I think there was really a recognition, and this hopefully this is what everybody here thought of, that expanding access for qualified voters to be able to cast their ballot is not at all the same with denying the fundamental right to vote to qualified voters. It's not a one-way ratchet in the way that Section 2 works. It's a very localized and fact-specific determination, but these are not just two interchangeable concepts. The goal should be to expand access to the franchise for every qualified voter. And you really have to ask yourself, why are the states that are passing these laws embroiling themselves in litigation? Why are they trying to go against that sort of access?
I think that pretty much captures it. I mean, I think we live in intensely partisanly polarized times, and what's really quite, I mean, maybe that's always true. It seems more true now than in the recent past, but I suppose if you read accounts of the 1830s, it was pretty bad then too. So I'm not saying that this, I wouldn't go so far as to say this is the most partisan of times. They were pretty nasty in the 1830s and the 1880s and in other periods, but even some of the smallest things like voting hours, polling hours at voting, some of the big disputes, I think, in Ohio and elsewhere have been, and again, it often shows up as sort of conservative state governments and maybe more liberal or more pro-voting local governments, particularly in urban areas. And so where the state is moving to standardize the voting hours across the state on some notion that that's more equal, without acknowledging that, in fact, in urban areas there are many more voters, and the proportion of polling places or voting machines to voters is very different than in rural areas, and that there's a justification for keeping them open. So you actually have fights about things which seem as straightforward and non-political as polling place hours and consistency. I mean, if you just began by saying, gee, shouldn't they be open the same in every county in the state? Sounds like makes sense to me. If then you point out and say, well, actually, the ratio of voters to machines or voters to polling places is significantly greater in Cleveland than it is in a rural part of the state, maybe there's a reason for the polling places to stay open 2 hours longer there. And you do sort of see, sometimes there are plausible arguments in favor of the rollbacks or the tightenings up, if you want to call it that, in terms of some aspects of administrative convenience or standardization. But you begin to peel back the onion, you begin to see that typically what's driving it, or at least what the consequence of it is, which can then be read back into in your basic res ipsa loquitur kind of way, is why are they doing this? And I think it's, I guess having tried to be a little bit positive a few minutes ago, it's like, it is, I think, profoundly troubling just how deeply something as basic to citizenship as voting has been made part of the partisan fight.
So on that note, it's an actual invitation for all of you to engage in these issues more and keep keep abreast of what's happening on this particular issue, but also in the Lawyers Community and Impact series. Thank you all for coming, and thank